Hello everyone, welcome back to our Legal Aid Chit Chat. Today our topic is on Public Prosecutor and Attorney General. What's their difference and their distinction? So back then in 2009, the former Bar Council President, the late Raja Aziz and Ding Joanne, wrote an article on this before. In that article, they discussed the scope of the Attorney General and the Public Prosecutor. Yue, can you share the screen of that article? Yeah, so that's the article they wrote. So what's important is that, let me just read from the article. So what's important is that it wrote that the scope of the Attorney General power in Malaysia has long been a subject of debate and controversy. He is the chief legal advisor to the government and is responsible for advising ministers involved in legal proceedings in their official capacity. But as public prosecutor, he is also entrusted with power which he uses at his discretion to start, conduct, or discontinue any proceeding for an offence other than proceedings before a Sharia court, a native court, or a court martial. His dual role has posed a real problem. A conflict of interest is bound to arise if he has to institute criminal proceedings against members of government. So this issue of the power of Attorney General and Public Prosecutor was actually discussed back in 2009. And so this is not a new topic that was raised recently. And so before we delve into talking the differences between the Attorney General and the Public Prosecutor, we would like to discuss what's the power of Public Prosecutor when in a criminal trial when a person is charged in court. So Joshua, would you is going to speak on this topic?
Yeah, hi. Okay, so I will speak in BM for the benefit of our viewers. Jadi hari ni saya nak mengulas pasal fungsi atau tanggungjawab pendakwa raya dalam sistem keadilan jenayah. Jadi bila kita cakap pasal kes jenayah, apa itu kes jenayah? Ya, jadi kes jenayah secara asasnya adalah satu kesalahan yang telah dilakukan terhadap sesebuah negara atau kerajaan. Negara lah, an offence against the state. Dan bagi kes-kes jenayah, pendakwaan akan dijalankan oleh pendakwa raya. Ya. Dan pendakwa raya ni sebenarnya dia adalah satu office, seorang individu lah, dan yang memainkan peranan sebagai pendakwa raya. Jadi dia mewakili kerajaan atau mewakili negara dalam mendakwa pesalah-pesalah yang didakwa telah melakukan kesalahan jenayah. Dan peranan pendakwa raya adalah sebagai penjaga kepentingan awam, guardian of public interest. Dan kita mungkin tertanya-tanya, jika pendakwa raya tu dia seorang individu, macam mana beribu-ribu kes jenayah di Malaysia ni takkan dia seorang yang kendalikan? Jadi jawapannya, kalau kita ikut struktur institusi pendakwaan, di atasnya terdapat pendakwa raya, kemudian beliau akan boleh melantik timbalan pendakwa raya, TPR atau Deputy Public Prosecutor, untuk membantu beliau dalam menjalankan kes-kes pendakwaan. Kemudian terdapat juga situasi di mana memandangkan terdapat banyak sangat kes, macam kes saman trafik, kes saman letak kereta contohnya, kuasa-kuasa pendakwaan tersebut diberikan kepada pegawai-pegawai pendakwa daripada jabatan-jabatan atau agensi kerajaan. Contohnya seperti pegawai polis, atau mungkin pegawai penguatkuasa daripada majlis perbandaran, dan ada juga kes di mana peguam-peguam persendirian juga telah diberi kuasa atau fiat untuk mendakwa. Terdapat Terdapat dua contoh yang saya boleh fikirkan dalam kes Najib, dalam kes SRC dan 1MDB. Terdapat peguam-peguam yang telah dilantik, yang bukan merupakan timbalan pendakwa raya, telah dilantik sebagai timbalan pendakwa raya untuk menjalankan pendakwaan terhadap Datuk Seri Najib. Dan satu lagi kes yang saya boleh fikirkan ialah kes tak silap saya kes Daphne I. King, di mana peguam bagi bekas suami beliau telah diberikan kuasa untuk membawa pendakwaan terhadap tertuduh yang dikatakan telah melarikan atau membawa lari atau memikat isteri beliau. Jadi tadi ada menyentuh seketika berkenaan kuasa pendakwa raya dalam sesuatu kes jenayah, iaitu the power to institute, conduct and discontinue a criminal case. Dalam bahasa Melayu, ia kuasa untuk memulakan, mengendalikan dan menghentikan kes pendakwaan. Jadi secara rumusannya, kuasa untuk memulakan bermaksud seseorang pendakwa raya tu dia boleh memilih untuk menuduh seseorang bagi apa-apa kesalahan. Jadi ada dua aspek. Aspek pertama ialah beliau mempunyai keputusan atau budi bicara untuk menuduh seseorang dengan apa-apa kesalahan, dan aspek kedua ialah beliau boleh memilih kesalahan apa untuk dipertuduhkan terhadap seseorang individu. Jadi contohnya bagi kes dadah contohnya, seseorang pendakwa raya tu dia boleh memilih untuk menuduh atau mengemukakan pertuduhan pengedaran dadah ataupun mungkin pemilikan dadah, bergantung kepada suatu fakta kes. Kemudian kuasa untuk mengendalikan pendakwaan, ia secara asasnya bererti bahawa pendakwa raya mempunyai budi bicara untuk menentukan bagaimana beliau ingin mengendalikan kes, bagaimana berapa saksi yang beliau ingin panggil, apakah keterangan yang beliau ingin kemukakan sebagai bukti dan apa soalan-soalan yang ingin beliau tanya kepada saksi-saksi. Dan seterusnya kuasa untuk menghentikan pendakwaan, bermaksud sekiranya beliau tidak ingin lagi meneruskan dengan sesuatu pendakwaan, maka seseorang pendakwa raya tu dia boleh memaklumkan kepada mahkamah bahawa beliau tidak ingin lagi meneruskan dengan pendakwaan, dan mahkamah akan membuat perintah yang sewajarnya, sama ada perintah pelepasan tanpa pembebasan atau perintah pelepasan dan pembebasan. Dan secara teori lah, atau secara kasar kuasa pendakwa raya dalam kes-kes jenayah. Tapi sebenarnya secara secara praktikalnya, pendakwa raya sebenarnya memainkan peranan yang sangat penting dalam satu kes jenayah. Contohnya bagi isu ikat jamin seseorang yang telah ditangkap dan dituduh di mahkamah, dan sekiranya dan secara kebiasaannya, melainkan ia kesalahan yang tidak boleh diikat jamin, seseorang tertuduh itu akan diberi ikat jamin. Tetapi dan pendakwa raya akan memainkan peranan yang penting dalam menentukan, walaupun ikat jamin itu adalah budi bicara mahkamah, tetapi pendakwaan akan memainkan peranan yang penting untuk menentukan atau sama ada beliau membantah terhadap terhadap sekiranya seseorang itu dibenarkan untuk diikat jamin ataupun terhadap amount atau syarat-syarat lain yang perlu dikenakan di dalam sekiranya seseorang itu diperintahkan untuk diikat jamin. Dan dalam mungkin semasa sebelum perbicaraan, kuasa yang agak penting adalah kuasa seseorang pendakwa raya itu atau pendakwa untuk menentukan apa dokumen yang perlu diberikan kepada pihak pembela atau seseorang tertuduh. Jadi di bawah undang-undang, seseorang tertuduh itu dia diberikan hak untuk mendapatkan sesalinan laporan polis, dokumen-dokumen yang akan diguna pakai oleh pihak pendakwaan di dalam kes pendakwaan, dan juga satu kenyataan fakta yang memihak kepada pihak pembelaan. Tapi secara praktikalnya, pihak pendakwaan sebenarnya mempunyai kuasa yang lebih. Mereka boleh memberikan atau membekalkan dokumen-dokumen yang juga tidak akan digunakan dalam pendakwaan kepada kes pembelaan. Dan bagi penyataan fakta-fakta yang memihak, pendakwaan juga boleh memberikan kepada pembelaan satu kenyataan apa isu-isu atau apa fakta-fakta yang mungkin boleh membantu atau memihak kepada pembelaan. Sebagai contohnya, saya pernah melakukan satu kes menggunakan senjata api. Ia melibatkan lanun di Somalia. Dan dalam kes tersebut, pendakwa raya menyatakan bahawa tertuduh tidak dijumpai sebarang kesan gunshot residue, sebarang kesan tembakan macam belerang daripada peluru senjata api pada badan beliau. Jadi ia merupakan satu fakta yang mungkin boleh membantu pembelaan dalam kes tersebut. Dan mungkin secara poin terakhir adalah mungkin dalam peringkat sentencing atau hukuman, di mana walaupun hukuman itu adalah budi bicara mahkamah, tetapi pihak pendakwaan biasanya akan mencadangkan hukuman yang sesuai atau yang wajar bagi sesuatu kesalahan. Jadi secara kebiasaannya, sekiranya pihak pendakwaan mencadangkan sesuatu hukuman, pihak mahkamah tidak akan melebihi cadangan yang telah diberikan oleh pihak pendakwaan. Jadi itu juga adalah satu, saya rasa satu privilege, satu benefit, satu manfaat yang diberikan kepada pihak pendakwaan. Jadi secara asasnya saya rasa itu adalah saya rasa cukuplah setakat ini sebagai rumusan berkenaan kuasa seseorang pendakwa raya dalam sesuatu kes jenayah. Terima kasih, Su.
Terima kasih Josh atas penjelasan kuasa pendakwa raya. Nampaknya pendakwa raya mempunyai kuasa yang besar dan penting dalam bicara mahkamah, di mana pendakwa raya boleh memutuskan perkara-perkara penting seperti jaminan, cadangan hukuman dan pembekalan dokumen. Jadi, apakah kuasa dan peranan Attorney General jika pendakwa raya sekarang mempunyai kuasa sangat penting? Amir, does the AG has more power and scope than the Public Prosecutor? And what is exactly the scope of AG, and what's the distinction between AG with the Public Prosecutor?
Hi everyone. Thanks, Sue. Today we're discussing about the role of the Attorney General. If we look at Article 145 of the Federal Constitution, which is the starting point of this discussion, Article 145 of the Federal Constitution has clearly set out the roles and the scope of the duties of the AG, whereby as the AG, he is supposed to be the chief legal advisor to the government. And the AG's appointment is based on the advice by the Prime Minister to the Yang di-Pertuan Agong. So he served at the pleasure of the Yang di-Pertuan Agong. So as an AG, um, he is supposed to advise the government of the day as to what are the legal matters that affect the government on policies, on every legal aspect that concerns the government of the day. In other words, to put it in a simple term, he's like a lawyer that is advising the client, and the client is the government. So that is the role of the AG. He's the chief legal advisor, and the government of the day is the client. At the same time, in our constitution, Article 145 also says that the AG is also the public prosecutor and have the power to institute, discontinue, or even and to conduct any criminal proceeding. As to the role and the powers of a public prosecutor, Joshua had explained extensively that the public prosecutor can decide whether to bring a particular case to court, to the criminal court, and can conduct criminal prosecution in court and decide whether to discontinue or withdraw any particular charge in court. So that is the power conferred to the Attorney General in his capacity as the public prosecutor. So you can see that in the Constitution, the AG plays dual roles. One as the advisor to the government of the day, and on the other hand, he's acting as the representative of the Crown to prosecute members of the public in criminal matters. Now, this issue about AG wearing two hats as the chief advisor to the government and the public prosecutor is not an old issue. Sue, you mentioned just now that there was an article by Raja Aziz way back in 2009. But if you go back down in history, historically, the post of the AG was a political post. If you look before Tan Sri Abu Talib, before he became the AG, you have Hamzah Abu Sama, and then you have Abdul Qadir as the AG. Those AGs were political appointees. They were members of the cabinet. They appear in parliament, and they are answerable to parliament because by virtue of the fact that they're MPs. And the actual role of a public prosecutor was delegated to the Solicitor General. So at the time when Tan Sri Qadir and then Hamzah Abu Samah was the AG, the day-to-day function and role of a public prosecutor was actually carried out by the Solicitor General. If my memory serves me correctly, at that point in time, it was Saleh Abbas as the AG, who actually wields the power or the function of a public prosecutor. So even though in law, in theory, the AG is supposed to carry these two functions, but back then in practice, it has been separated. Now, when Mahathir became the Prime Minister, he appointed Tan Sri Abu Talib as the AG. And it was during Mahathir's time as the AG, as the Prime Minister then, Abu Talib plays this dual role. So now he is the chief advisor to the government of the day, and by virtue of the fact that he came from the AG's chambers, he's also an experienced DPP, so he also at the same time wears the hat of a public prosecutor. So if you look back in time, during that period of time, you could see that there was also an issue with regard to the case pertaining to the former Deputy Speaker, DP Vijayendran. Of course, being a Deputy Speaker, I think he was also from MIC. There was an issue about this video, and he was there was a decision whether he should be prosecuted, and there's a lot of issue surrounding that particular case about whether the evidence was disposed of by, I wouldn't mention names, but yeah, that's one of the issues. So you could see that during Mahathir's time as the PM, that's where the roles of the AG and public prosecutor realistically merge into one, and has been practiced until now. The problem when you have this kind of powers is that there may be instances whereby the public prosecutor is supposed to prosecute a member of the government of the day. Now, if you're supposed to prosecute a member of the government of the day, at the same time you are also the chief legal advisor of the government of the day, there will be a conflict of interest, or at the very least, the perception that there will be a conflict of interest. So this is an issue which we have to look into carefully in order to move forward, whether we still want to have the AG wielding these two big responsibilities, or whether the roles and functions of an AG and a public prosecutor ought to be separated, like what we have in UK, for example, or in India, whereby the AG is solely responsible to advise the government, and the public prosecutor, or you can have an office of a director of public prosecution who will focus solely on criminal matters involving the state. I hope that answers your question, Sue.
Yep. Thank you so much, Amir, for explaining the roles of AG and what's the difference between the public prosecutor and the AG. So just like Ami mentioned Article 145 of the Federal Constitution as the starting point of the AG. And from what I understand is all along our court's position follow Article 145, where they don't compel or they cannot compel the AG to institute proceedings or to continue proceedings that they don't want to. But I also read somewhere recently that the position has changed. Sinyu, would you explain the case laws or the position of the court recently and their developments?
Yeah, so with Article 1453 of the Federal Constitution, it basically empowers, it vests the prosecution powers of the federation within the Attorney General or the Public Prosecutor, because they are one and the same. So the court have in the past interpreted it to mean that this discretion that is exercised by the public prosecutor is beyond the scope of judicial review. So it is something that the courts simply cannot question, whether it's to institute or it's to continue or discontinue it. That was the decision of Repco Holdings. I think it's by then the judge of the Court of Appeal, Gopal Sriram, who is now deputy public prosecutor, ironically. So yeah, he basically said that we can't question, simply cannot question. The problem with that decision is that it vests so much power within one particular person, because the Attorney General or the Public Prosecutor is the only one in the entire country that can commence or discontinue criminal proceedings. And nobody can question him. So that becomes very problematic, because the Attorney General is appointed by the Prime Minister. So what happens in a situation where the Attorney General has a file before him, and it says that, okay, these are criminal offences by the Prime Minister or by members of the administration of the current government, which appointed the Attorney General. So you have a situation where the Attorney General, even if in their view they can act independently, but in the public's view they simply couldn't. So that's a very problematic situation that has been created. And I think a lot of people, they have written about this, and this is not something new. Even Pakatan Harapan, when they came into government, as part of their manifesto, they said they are going to separate the office of the public prosecutor and the Attorney General. But that wasn't done. I don't know why that wasn't done. They had 1.5 years to do so. In fact, if anything, that should be the first thing for them act on. Just bring in a constitutional amendment, and given the political climate back then, I'm quite sure that the members of the opposition would support this constitutional amendment. But as we have seen, governments that has come into power, they do not want to lose that power. They prefer to, preserve that power. And I suppose in their folly and arrogance, they lost that power. And now we are back to a situation, we're in the same situation where there is no commitment towards separating the posts of the AG and the PP. But luckily, there has been judicial developments in the past few years, changing or moving away from this decision by Sri Ram in Rapco Holdings, that the decision of the discretion exercised by the Attorney General or the Public Prosecutor is beyond the scope of judicial review. And, just so that it's very clear, I'm going to read out that portion because I don't want anyone to say that, I'm misinterpreting Rapco Holdings. So I don't think we can share it on the screen. I'll just read it out. And this is in the High Court at page 1997, 3 MLJ 681 and page 690. And this is what the judge said. The importance of the propositions formulated by the learned Lord President in these two cases is that, as a matter of public law, the exercise of discretion by the Attorney General in the context of Article 1453 is put beyond judicial review. In other words, the exercise by the Attorney General of his discretion in one way or another under Article 1453 cannot be questioned in the courts by way of certiorari declaration or other judicial review proceedings. So that position had since changed in the past few years. I think it perhaps started in this case by Rosli Dalan, who has been appointed as the PNB director. So congratulations to him. Rosli Dalan against Tan Sri Abdul Ghani bin Patel, who was the then Attorney General. And in that decision, the High Court, Justice Wazir Alam Maidin, he expressed doubts on whether or not that proposition of law is still good in this day or an age. And in that case, what happened was Rosli Dalan, he brought a civil suit against the then Attorney General for malicious prosecution and prosecutorial misconduct. So the then Attorney General, he sought to argue that he enjoys absolute prosecutorial immunity, but Justice Wazir Alam, he rejected that. So he said that there's no such thing as absolute prosecutorial immunity under our laws, and he also expressed doubts on whether or not the decisions of the Attorney General is put beyond question by the courts because of this whole argument on separation of power. So that after that decision, there was a federal court decision who expressed the same views in terms of whether or not the courts can review the decision, the exercise of discretion by the Attorney General. And the federal court, even though it was just obiter, it was not material to the decision, because that decision concerned the exercise of power not under 1453 but under separate law. So that obiter was later quoted and followed in the most recent High Court decision, where the High Court had effectively quashed the charges against the ex-AIAC director or chairperson, director, Sundra Raju. So the High Court, the position now is that the discretion of the Attorney General can be reviewed, but I think we are still at very early stages of developing this area of law, because there would certainly be questions on whether or not the review should be a limited review, or under what circumstances it can be reviewed. But either way, it's very good development, because effectively what the courts have done is to allow for a certain degree of check and balance against the exercise of discretion by the Attorney General and the Public Prosecutor. And it's moving forward. This is something that members of civil society and members of public in general should not stop advocating for. Pakatan Harapan has very clearly and obviously failed in fulfilling their manifesto. So now we are stuck with Perikatan Nasional, and I think there needs to be more advocacy on separating the offices of the Public Prosecutor and the Attorney General. Thanks.
Right, thank you, Sinyu. Edmund would like to add on that.
Yeah, I think we need to get to the heart of the matter, and what's on everybody's mind is the AG's position being used for political persecutions. So when the government is in power and there is a certain AG that is appointed by the government, the perception of the public is that certain personalities are going to be prosecuted or persecuted by way of the AG exercising his or her power to commence and conduct prosecutions. So we are in a state now where the independence of the AG is being discussed and debated, but also really, if that Amir said, if the AG is a political appointee, can we really expect the AG to be independent, assuming the AG is also the public prosecutor? Therefore, the bar's position, my personal position, and I think many people think it is time to separate the AG's office from the public prosecutor's office, have a separate office of director of public prosecutions, something like in England, which has a budget and resources that directly reports to Parliament. The AG then only becomes a servant of the government or cabinet. As the last AG said, he is the AG for Pakatan Harapan, whether rightly or wrongly. But then the AG then only plays that role, and the AG then is biased in that sense. The AG does not need to keep up appearances of independence. So maybe we are all barking up the wrong tree, because the position of the AG has always been a dependent position, that we cannot expect the AG to be independent. It's not that something I like to say, but in reality, if the AG has always been a political appointee and has absolute discretion, then we cannot ask the AG or expect the AG to be independent. So rightly or wrongly, the past AGs and the rest of the AGs, when we're talking about the independent powers of the AG to prosecute, where are we heading when the constitutional position has always been that the AG is also the public prosecutor? So I think moving forward, there needs to be a separation, as well as a new public defender's office. I think the legal aid system that the bar provides is excellent, but it is not a substitute for government's obligations to provide legal aid for all accused persons who are impecunious. So we need to, one, have a separate director of public prosecutions that's separate from the AG. Two, we need to have a public defender's office that's separate from the office of the public prosecutor, but also separate from the AG's chambers.
Right, thank you, Edmund. And now we will be answering some questions from the audience. The first question we have is, the audience asks, can she know how can we strike a balance between Article 1453 and Article 8, where everyone is supposed to be equal before the law, but the public prosecutor have the discretion to charge the accused under the offence that he preferred? Ami, could you answer this? Ami, your mic is muted.
Yeah, I think that's a problem with Amir's mic. I mean, your mic is still muted, I think.
Okay. Can you hear me now?
Yep, can hear you.
Okay, thank you for the question, Sue. Sorry about the technical glitch. The question that was posed just now essentially had been addressed by all of us just now. In order to ensure that there is this transparency, to ensure that there is this perception and in actual fact that there will be this fair assessment of the case, we need to separate the office of the AG and that of the public prosecutor. There's no two way about that. If you ask me, that has to be the way forward. And for the public prosecutor, you need to look at the facts of the case objectively, looking at the strength of the evidence, looking at the weaknesses of the case. One should not prosecute a particular case just because it is popular to do so. One should not prosecute the case because there is a demand by a certain segment of the society that this individual ought to be prosecuted. That should not be the case. The public prosecutor must always be guided by the facts, by the investigation papers, and by the strength of the case. If there's really a case, only then one should be prosecuted in court. One should not be prosecuted just to give certain political mileage to one party or the other. But if you have a fused profession, there will always be this perception that the decision to prosecute someone or the decision not to continue with the prosecution of a certain individual may be tainted or may be influenced by political consideration. And the reason why the public will have that concept, that perception, is because of the appointment process of the AG. We have no choice because we are guided by the words in our federal constitution that the AG shall be appointed based on the advice of the Prime Minister to the Yang di-Pertuan Agong and shall hold that office at the pleasure of the Yang di-Pertuan Agong. So you're looking at the appointment process, it can be debated, it can be argued that the AG, who also carries the power of a public prosecutor, in a way can be subservient to the government of the day. If you look at the provisions in the federal constitution. So we need to amend the federal constitution. There have to be separate bodies for these two specific functions. They should not be merged into one institution in order to avoid this unnecessary perception that the AG is prosecuting someone because of political consideration. That's the question, isn't it, Sue?
Yes, that's the question.
Okay.
Thank you, Ami.
Okay.
We have another question. It's by
No, but the
Nazira.
question really is, if there is absolute discretion, this is the second layer of the question. Then you cannot assert Article 8.
Yeah.
So the question is, if you charge Amir for one offense of stealing a triathlon bike, but then Joshua also was with you stealing the bike, and the AG charges Amir but doesn't charge Joshua. Is the omission to charge Joshua a violation of Article 8?
Yeah, so
Can I just answer that, Senor? I think if you look back at the decision of the federal court back then, Long Beng Samad, a very famous case. I mean, if you study your CPC, in that case, the court had decided that you can't question, assuming that someone is in possession of a firearms and maybe some few ammunition. Under the law, you have various legislation that can be used in order to prosecute that particular individual. You can charge that person under the Arms Act. You can charge that person under the Firearms Increased Penalty Act. And when we used to have the ISA, the said person can also be charged under ISA. So, under that instances, if you follow the decision of Long bin Samad, the AG can decide whether to charge that individual under ISA, Firearms Increased Penalty Act, or Arms Act, which is the most lenient legislation among the three. And the court in that in the Long bin Samad said you can't question the decision of the public prosecutor if he decides to charge the said person under that particular legislation. Of course, it creates this perception that this is unfair because another individual who may have committed the same offense may be charged under the Arms Act instead of the Firearms Increased Penalty Act or even the ISA. So that was then. And Senor, you mentioned just now that there seems to be a trend or movement towards the position whereby that discretion by the public prosecutor is no longer absolute. Now, if it can be shown that the decision to prosecute someone is tainted with mala fide or wrongful consideration, or there is a decision by the public prosecutor not to prosecute someone despite overwhelming evidence, shouldn't the public or shouldn't certain interested party be given the right to challenge that decision in the court of law? My point of view is that we have to move toward that direction.
Yeah, but on the issue of discrimination, right? I mean, it's not a great argument for discrimination because you are basically saying that I am discriminated because I am charged with a criminal offense, but my co-offender is not charged with a criminal offense. So I don't think it's a good argument for discrimination because the law allows for discrimination as long as it is justifiable and the objective is a legitimate objective. We're not talking about discrimination in law here, but we are talking about discrimination in treatment. So, you know, I think whether or not it violates Article 8, whether it violates the right to equality and non-discrimination, it's something that is quite heavily dependent on its facts. I don't think that it is, and it will be in any case an easy case unless there are very obvious fact to suggest that there is a clear discrimination in terms of treatment. Probably in cases where I am being prosecuted simply because I'm Indian, or I'm being prosecuted simply because I'm Malay or I'm Chinese, then you could make out argument on Article 8 that the decision to charge only Indian offenders or a decision to charge only Chinese offenders or Malay offenders, that would amount to discrimination in my view, but it's very hypothetical.
Can I also add, Senor, because to give another example, there may be instances whereby you have a number of offenders committing the same offense. Like, for example, gang robbery, whereby in order to move forward, the prosecution has to rely on maybe one or the two of the co-defendants to give evidence, direct evidence. And in that circumstances, realistically, you need to have some sort of a plea bargain, maybe with one of the two offenders, so that that person could be crowned a witness to give evidence against maybe the main culprit. So in that case, the public prosecutor ought to be given that discretion in order to prosecute the robbers. So if you
Yeah.
said all of them should be charged and there is no other evidence, save and except for the oral testimony of one of them, what choice does the public prosecutor has? So you have to look it from that point of view as well. So to say that the decision to prosecute someone or not to prosecute someone would automatically violate Article 8 is wrong. I agree with your view. You cannot simply say, oh, it is an infringement of Article 8, because certain case has to be looked from a certain angle, and there are a lot of dynamics involved, especially with regard to the presentation of the facts and evidence.
Yeah, so it's like that Riza Aziz situation, right, where it's reported that he is asked to be a witness in against his stepfather's case. So we don't know exactly what was the plea bargain that was struck there, but yeah, so it goes back to the two things, isn't it? Whether or not that decision to discontinue, not just in Riza Aziz's case, but in cases where they are co-accused, whether or not the purpose or the objective that the decision to discontinue is that the AG is seeking to achieve by discontinuing is one that is legitimate. If it's purely political, without any other reason, then you could say that the decision to do so was not legitimate. And the second thing is whether or not that purpose, there is a justifiable reason between that purpose that they're seeking to achieve and the discontinuance of the charge. And in cases where there are no evidence and you need evidence of co-accused where they cooperate and there's a plea bargain that's being struck, they turn prosecution witness. So that is something that can be justified. Yeah.
Right. Thank you, Edmund. Thank you, Ami and Sinyu, for that discussion just now. Next, we have another question from Nazira. Nazira question is, the appointment of the AG should not be political. Do the speakers think the AG should have security of tenure to safeguard his independence? Josh, would you answer this?
Yes, I think our previous speakers have spoken about how unfortunately the position of the AG is political. He's a political appointee. But to answer the question, yes, having a security of tenure for the AG technically may be an issue, maybe a solution, but I think practically it may not be feasible because the AG, being the chief legal advisor for the state, if he is not in favor with the current government in power, he may there may be an impasse in terms of in the working relationship between the government and the AG. So yes, it may be a solution which we may want to consider, but I think the better solution is actually to separate the office of the AG and the PP.
Can I add on to your answer, Josh?
Yeah.
Okay, now the question is, should the appointment of the AG should be political or non-political? I think we have to go back to the main issue, whether they should be, the AG and the role of the PP should be fused. AG does not need to be permanent. Like I said, AG is the chief advisor to the government of the day. If we have a separate roles between the PP, the public prosecutor, and the AG is just like lawyer advising a client. If the working relationship between the client, which is the government, and the AG, i.e. the lawyer, is not workable, then of course the client is entitled to sack the lawyer and get a new lawyer. So as a chief legal advisor to the government of the day, the AG position can be political because you're supposed to advise the client. But with regard to the role of the public prosecutor, it should not be political. The role of the public prosecutor is not to serve the interests of the government of the day, is not to serve the interests of a particular political party or ruling government party, but the role of the public prosecutor is to ensure that the wrongdoers will be prosecuted based on the facts and evidence in the interests of the public. So, the question should be that, should the role of the public prosecutor be permanent? As far as the AG, as the advisor to the government, the AG can always be sacked if the government is not happy with the performance of the AG. But as far as the role of the public prosecutor, which is a separate question, that issue has to be studied carefully. Maybe the role of the public prosecutor ought to be made more permanent. There should be some sort of security of tenure so that there won't be any undue influence with regard to the role of the public prosecutor. So that's my take to that question.
Okay, thank you, Josh and Amir, for the discussion. So the question now is, after all this discussion on AG and PP have to be separated and how the courts have been progressing from the previous position, so what should the government now do in relation to this issue? Edmund, would you?
The question by Nazira is, can you hear me? The question by Nazira is a very good question. Because for me, while we need to separate it, the way that we appoint personalities to positions need to be reviewed and improved. I think in some countries, leaders of important bodies, for example, the AG's office, Public Prosecutor's office, Election Commission, these positions go through a very strict, stringent, difficult process, including live interviews on TV, including questions and answers and comments by the public. Of course, it's not foolproof, but compared to the situation we have now, and you have seen recently how under the new government, leaders of GLCs and executives of big corporate companies that are linked to the government have either resigned or been politely removed. And we also see new appointments to these very important posts. So the question is not only about security of tenure, because I believe the AG, if the AG has to be removed, has to go through a tribunalization process, right? Like a judge. So even if
that
you
was
have
the
security
case.
of tenure,
That was the case.
Even if you have security of tenure, that doesn't solve the question, because today's topic, I think, arose due to the different discourses about the independence of the office. And so we see that now the office can be used for good, but it also can be abused. And moving forward, if you ask me what the government should do, having these new select committees, the select committees under the Pakatan government was good, but the selection process before the Yang di-Pertuan Agong makes the decision has to be more robust. It has to be more transparent. It cannot be done in secret. And if there are positions of GLCs where people are removed or left or going to be removed, reasons must be given. The current AG has written quite extensively and quite extraordinarily, because from my history, AG doesn't really send long press statements why there were decisions to discontinue or to prosecute certain people. So the AG himself now has come up with a practice of explaining his decisions, which is good. Whether we agree or we don't agree is a different question. But if you ask then the government, why the government are doing certain things or why people have been removed or people are resigning, then that should also be an explanation given by the relevant authorities. So this is things that are moving forward. Hopefully this government, I think a lot of us have reservations about the government, but the idea is that if the government wants to regain a bit of public trust or credibility, then there should be moves towards this. Otherwise, for us personally, I think many of us just says, I think let's just go back to the ballot box. I think it's time to, stop this nonsense of one side having numbers, another side having numbers, and then a third side saying, let's set up a new political party. It is not good for the stability in terms of our economic recovery. And it's only good for those people who perceive that they are in power. That's what I have to say, Su, at the moment. Thank you for this new government.
So,
But it's the Ami, you go ahead.
No, I agree with regard to the appointment process, especially when it comes to key position in the government or key position that deals with the public interest. Remember, like back then when the CJ's appointment, it was just based on the advice by the Prime Minister to the Yang Petun Agong. There was also a big debate back then whether the selection process or the nomination of the CJ was transparent. And slowly we have moved and we established the Judicial Appointment Committee. So the appointment of judges and after the CJ will be discussed by the GAC, and then it will be discussed with the Prime Minister. So perhaps we need to have a similar commission that looks into the appointment of this key important public position, the position of the AG, especially since the AG and the Public Prosecutor are now fused. And if we are able to reach a point where the two roles will be separated, they have two separate officers, even then, the office of the Public Prosecutor and the office of the AG must be properly scrutinized. Even in the US, the AG's appointment was heavily scrutinized, like AmerBON correctly pointed out. So, yeah, going to the ballot box, that is not the way forward. We need to have more, we have to have some sort of proper structure in order to avoid any unnecessary allegation that the appointment can be questioned. That's the way forward. Yeah, Senor, go ahead.
Yeah, the whole idea, I just checked, the whole idea why, AG and PP, the officers are fused is because back in 1957, there just weren't enough law graduates or people who had sufficient legal knowledge and skills to be able to run two separate offices. So that's why they decided to combine both of it together with the judicial and legal services. But now, we have law schools producing law students like factory, like McDonald's delivery. I don't think we have that problem anymore, and that's something that should be reviewed. Separation of the officers. I think appointment is one thing. You need to have independence from government in your appointment, but the separation is also another important aspect of it, because we have seen in debates, or wasn't much debate, like it was like more mudslingings from both sides that when our previous AG Tommy, he made political decisions. Why are you complaining about political decisions that being made by the current AG? So that's why I said that's the first thing the Pakatan Harapan government should have done, is to separate the office of the PP and the AG, because everything that you do, even if it's with the best of intentions, it's gonna be tainted by this political brush because of your appointment. So it's like what Edmund has said, and it's something that is quite problematic, and we are basically in a tennis or a ping pong match where things are being hurled at one another, but no one is really there to solve the problem. So it's quite a depressing situation for the country, and it's important to know that whoever the AG is, the accused will want to engage the AG either by way of letter of representation or in court. So how decisions are being made, that too needs more transparency.
Thank you, Sinyu. Edmund, you would like to add on something?
The former CJ Arifin Zakaria actually started, I remember, the move to separate judicial and legal services, and that's a good move. I'm not sure where the position is now, where that separation has been, where it's going, but it's to separate the AG's office from, immediately becoming a magistrate, and then the magistrate becoming a DPP, and then moving that way. So I think that's one good move. I think that should continue under the new CJ, to make sure that there's a bit more separation and no perception that area is fused. So under the new government, I think that should continue. The second important position that was being discussed also is about how we should, as I said, set up a public defender's position and having legal aid be more comprehensive as aid given by the government. And I think what was interesting is that you now suddenly see a flurry of former AGs rushing to sign affidavits. We have an AG who said that he was not sick, but he was asked to resign some time back. And then he has come up with an affidavit. And then a few days ago, another AG talks about, a former AG, talks about a conversation he had with a former judge. I do not know why that came about, but it seems there is an affidavit as well by that AG. When a long time before the political upheaval, you never see AGs affirming affidavit to that extent. So I'm not sure what the situation, why the situation has come about to precipitate these affidavits by AGs, but it shows the AG's word is very powerful. I think Tommy mentioned before that the Attorney General is the most powerful person in Malaysia, even more powerful than the Prime Minister, I recall, because the AG can move prosecutions even against the Prime Minister. So why are the most powerful persons previously now affirming affidavits for court matters that will subject them to cross-examination on those affidavits? And you can see also, if you assume what they are saying on those affidavits are true, what occurred previously may be quite controversial, and where their political position lies as well is quite controversial. So I'm saying you cannot say AGs or Attorney General, there cannot be a perception that they are independent, because they are political appointees. They are not independent, or, well, we try to make them independent, but they will never be. So unless we change the constitutional position or we change the law, it's not going to be easy to say that the AG will be a non-independent, that the AG will be an independent office. In fact, it's not. I don't think it's seditious to say that the AG is not independent. I don't know. Amir may have a different view on that.
No, I agree. I mentioned just now that the AG, being the chief legal advisor to the government, will always try to serve and look after the interests of the government of the day. So if you look in the UK, you can US, the AG will definitely be part of the government, but from the legal point of view, from the legal perspective. So I want the structure to be amended. We have to have this separate provision whereby the PP have got nothing to do with the government of the day, which is a permanent office that looks into criminal matters independently, objectively. The AG, by virtue of the fact that being the chief advisor to the government, would advise the government of the day. And the tenure of the AG in a situation where there's a separate function is up to the client at the end of the day. So you see in UK, if the government is not happy with the AG, they can sack the AG. But the Crown Prosecution Service in UK will still remain and decide on cases on criminal matters and prosecute without any interference or intervention from the government of the day or the AG. Yep, that's all.
Right. Thank you, Amir. Thank you, Edmund. And we are reaching the end of our session. So next week we will be talking about employees' right under the Employment Act. And yeah, that's all. Thank you so much for our speakers and to our audience who stayed through our session. Thank you.
Okay, thank you.